Hello and welcome to Connected with Latham, where we discuss ideas, legal developments and business trends shaping the global economy. I'm Rob Moulton, a partner in Latham & Watkins' London office. In this episode, part of our 10-part series complementing Latham's 10 key focus areas for UK regulated firms in 2024 report, we discuss artificial intelligence. I'm joined by my colleague from the London office, partner Fiona Maclean. Fiona, welcome to the podcast.
Hi, Rob. Great to be here.
Now, there are no specific rules in the UK regulating AI. So what should firms be thinking about and what should they be doing when thinking about their approach to AI?
You're right, Rob. As it stands, there are no AI-specific laws or regulations in the UK. Indeed, the UK government has been vocal about its intent to, and I quote, avoid heavy-handed legislation which could stifle innovation in AI. However, that's not to say there are not rules which firms and other companies building, offering, or using AI need to be mindful of. In the UK, we've seen a white paper published by the UK government last year, which specifically empowered the UK's existing regulators to come up with tailored, context-specific approaches that suit the way AI is being used in their sectors. And as a result, we've seen considerable activity by the UK regulators, including the FCA, exploring both the opportunities presented by AI and the risks that need to be addressed. Firms, therefore, must ensure that they're developing an AI strategy which takes account of that guidance and the information that's being published by the regulators. A good starting point, I would say, for any firm is to consider the 5 core principles that are specified in the white paper that I mentioned. They are safety, security and robustness, transparency and explainability, fairness, accountability and governance, and contestability and redress.
And so a committee like that, Fiona, what are the key risks that you think it should be focused on in 2024?
The risks are plentiful when it comes to AI, and I think a lot of the publicity surrounding the launch of ChatGPT and all that has followed just goes to highlight how much the regulators and indeed the public are focused on some of those risks. If we look at it purely from a legal perspective, I would say there are those which are industry agnostic and exist for any company using AI, and those include data privacy, consumer law, and IP protection, for example. And then in the context of regulated firms, we must then layer on the specific considerations for those in the regulated space, such as senior manager rules and consumer duty. And so maybe we can talk through some of those in a bit of detail and just highlight some of the key issues that, as I say, an AI governance committee or indeed just any firm looking to use AI need to be mindful of. So AI is, by its very nature, data-centric, and so presents many legal issues around the protection of such data. If firms are using proprietary or customer data to train AI models, this needs to be scrubbed for client information subject to NDA, trade secrets, or indeed, information that may be subject to regulatory restrictions on use, such as MMPI. Particularly when using third-party AI tools, firms should be aware that the data they are using may become public, or at least be utilized by the model so that it can learn and thus could form part of any output produced by that model. So confidentiality of the data and determining which data the firm is comfortable using when it comes to AI is a key starting point. AI often will also use personal data. In some cases, vast amounts of personal data are used to train and test AI models. This is not surprising. Obviously, firms will hold considerable amounts of customer data, and in order for their use of AI to be leveraged in their customer-facing tools, personal data will be used both for training purposes and in some cases for output. There are a number of issues that need to be thought about when that's the case. Firstly, and I should start by saying we're going back to sort of key principles here when it comes to the use of personal data. But firstly, the consumers themselves, the data subjects, need to be informed about the fact that their data is being used for AI purposes. That will be done through either the privacy notice or any form of policy that is provided to those consumers. Firms will also need to think about how they can comply with data subject rights when it comes to the use of AI, and that can be challenging because, as we've already mentioned, the amount of data that is fed into an AI model can be vast. And in many cases, it's not really structured in that AI model. Essentially, the AI model is simply using that data to learn. The firm also needs to be mindful, and I think this is particularly pertinent in the financial services space, around automated decision making. So essentially, we're looking at key decisions that may affect that individual where it's being made by an AI model, and the consumer must be given a right to object, and they are also entitled to human oversight. So essentially human intervention in relation to the decision that's been taken. And then moving on, but again, sort of still building upon those issues relating to data, we need to be mindful of consumer law requirements, and specifically in the UK, the heightened consumer law requirements imposed by the FCA's Consumer Duty. So what we mean by that is any firm leveraging AI needs to think about transparency and explainability. And so that comes through both in terms of their design of AI models and then ultimately the use cases. So there needs to be safeguards and guardrails in place to ensure that there is no foreseeable harm caused to the consumer by AI. And that may be a case of considering things like bias in the data sets that are being used to feed that AI model. And then just a brief touch on the IP issues that I mentioned as well. Now, this will often be less pertinent for a financial services client because we won't necessarily be looking at IP-heavy use cases in relation to AI. That's not obviously always the case, but we're not necessarily looking at output that we may want to protect from a copyright perspective. But ultimately, firms need to be mindful of the sort of IP framework within which they're operating. And we've recently seen announcements by the UK government around potential amendments to existing UK copyright law, which will specifically address the issues that arise in respect of AI.
So that's interesting, Fiona. Can you give us an example of how AI could impact upon consumer outcomes?
Yeah, and I think the potential for that is plentiful, actually. There are many instances or use cases for AI in the financial services sector which could have an impact, whether that be application for a loan where an AI model is being used in evaluating that application and the decision that is being made by essentially an AI system. At the other end of the spectrum, obviously, we've got generative AI now, because let's face it, AI has had a role to play in a lot of technology for many years, but generative AI now is a huge evolution in the AI landscape. And so with that, you could see a scenario where a regulated firm is using an AI-powered chatbot, and that chatbot may, as it continues to learn from the communications that it has with individuals, it could produce unwarranted outcomes. So whether that be that it may not fully appreciate or understand the complexity of what the customer needs, and so actually it's simply failing to meet the consumer's requirements, or actually could be bordering on the lines of providing investment advice to consumers. And so it definitely gives rise to the potential for murky waters there.
It's interesting to think of the things that the UK do, but of course then in a global context for many firms in this business. So how do we grapple with the international side here, how different rules are developing, like in the EU or elsewhere? How should firms look at this different and complex international landscape?
Yeah, it's certainly a global issue. Nobody can look at AI purely within the borders of any particular country, and that's because the data is often gathered from across the globe, and also the use cases are far and wide. Across the AI landscape, if you like, we're seeing evolution of laws, and there's been a bit of a race to arms in terms of who can get there first with the new laws that have been introduced. So you mentioned the EU there. In December last year, we saw political agreement reached in respect of the EU AI Act. And now in January 2024, we're just waiting for the final text to come through. We've got a fairly good understanding of the requirements that will be imposed by the EU AI Act, but it's important to note that they're very wide-reaching and have significant penalties, up to potentially 7% of global annual revenue. And so it's not something that firms can ignore. Similarly, across the pond, we've seen considerable regulatory activity, and last year there was an executive order issued by the Biden administration in respect of AI. And so with all of these developments where countries are both taking the UK's approach and sort of saying we've got an existing body of law that can be used to manage the risks around AI, and also when you've got these countries which are specifically developing and introducing new laws to address AI, firms need to look at this as a global issue and need to involve all of their relevant stakeholders. It's not an easy task to satisfy the differing requirements, but there are certainly a number of key trends and themes that exist throughout all of the AI regulation that we've seen coming through in recent years. And I think if we go back to those 5 core principles that I mentioned at the outset that are specified in the UK white paper, we'll see that being used as essentially the building blocks for other AI legislation as well. And those are the primary factors that a firm should think about when leveraging AI.
Well, lots to ponder there, Fiona, and thanks very much for joining me.
It was great to be here. Thanks, Rob.
And thank you for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or wherever else you get your podcasts. And if you'd like more information about the topics in this podcast or to access our 10 key focus areas in 2024 report, please visit the links located in the show description. And we hope you'll join us again next time.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.